The registrar, criminal division, is directed to avail a list of all lawyers in the criminal division for all the state brief, which criminal division has a pool of lawyers on the state brief. So, in order for the accused person not to suffer with the challenges of the legal team which keeps coming, the registrar should avail to the accused person that list of all lawyers in the state brief in the criminal division. Send this list to Zira through the criminal officers so that the accused persons can look at this list of lawyers and be able to choose from them the lawyers of their choice. In alternative, for the purposes of this trial, if the accused persons don't choose the lawyers from state brief on their own,
if what you have provided that we start trial on Wednesday is the case,
why can't you wait for court to clarify?
you see, sir, the reason indeed we are very frustrated and we were even unwilling to come to court because this in many times appears as if we are irrelevant. We present whatever we present, court goes on with its script. So the impact will be that possibly you may have to try us in absentia so that it hastens the process. We give up our right to defend ourselves. You write a judgment and we deal with the judgment.
Well,
it will arise because even the trial by state lawyers is a matter that we raise the concern about because we have been hearing it right from the way back that our lawyers will not be allowed to represent us, and indeed they have been tortured. The torture pictures published to the public and all the other lawyers, who after the pictures that were published of Counsel Yasser under torture.
The registrar, criminal division, is directed to avail a list of all lawyers in the criminal division for all the state brief, which criminal division has a pool of lawyers on the state brief. So, in order for the accused person not to suffer with the challenges of the legal team which keeps coming, the registrar should avail to the accused person that list of all lawyers in the state brief in the criminal division. And then this list will be given to the accused persons through Zira. For the accused persons to look at this pool and choose as a fallback, choose some lawyers of their choice for the purposes of this trial. And this registrar is directed to do it by tomorrow 14th and send this list to Zira through the criminal officers so that the accused persons can look at this list of lawyers and be able to choose from them the lawyers of their choice. In alternative, for the purposes of this trial, if the accused persons don't choose the lawyers from state brief on their own and make their own choice, then I go ahead and make the direction that the registrar of criminal division by tomorrow, if the accused person have not chosen from the pool, then let the registrar go ahead and appoint the lawyers on state brief to help court and accused persons to proceed with this trial.
if what I heard and I have recounted is the case, then quite clearly the intention of this process is not a fair trial. Very clearly. Fair trial. Very clearly, very explicitly, non-derogably provides that the accused should be accorded enough facilities and time to prepare. If what you have provided that we start trial on Wednesday is the case,
why can't you wait for folks to clarify?
this is, sir, the reason indeed we are very frustrated and we were even unwilling to come to court, because this in many times appears as if we are irrelevant. We present whatever we present, court goes on with its script. So the impact will be that possibly you may have to try us in absentia so that it hastens the process. We give up our right to defend ourselves. You write a judgment and we deal with the judgment. Well, it will arise. It will arise because even the trial by state lawyers is a matter that we raise the concern about, because we have been hearing it right from the way back that our lawyers will not be allowed to represent us, and indeed they have been tortured. The torture pictures published to the public and all the other lawyers, who after the pictures that were published of Counsel Yassar under torture.
May it please this honorable court, I'm Thomas Jatiko, Assistant Director of Public Prosecution. My Lord, I'm appearing together this afternoon with Richard Gumbuka, Chief State Attorney. My Lord, the three accused persons are present in court. However, my lord, the counsel representing the accused person are all jointly and severally not present in court right now. My lord, this matter was adjourned to today, the 13th of July. For hearing of the prosecution case as per the ruling that we received. And my lord, the prosecution is ready to proceed.
Say you are ready to proceed.
Yes, the witnesses in the court premises.
The
Not,
witnesses are
they are around, not inside the court here, my lord.
I came here by duress.
then first we want to finish. Yes, go. Move the abstract, then the address.
Yes.
There a report on the issue of legal representation, why they are not here.
Yes.
Legal representation.
Yes. Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which took us to the defunct military court martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May of last year, yet from December, disclosures were completed in June. Our lawyers begged for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. the same state saying we are the ones abusing the process. Therefore, constitutional rights must be stripped. So, Mr. Judge, I beg this court to hear our application to resolve the issue of our lawyers. And once resolved, allow us time to access disclosures, and also to give us the record of proceedings. And we shall be ready to face their witnesses. As I ask for, Mr. Judge.
This is the ruling of this honorable court. I have very carefully listened to the concerns from the chosen persons and the prosecution. The concerns and the reply from the prosecution are on the court report are not reproduced. And for the interest of time, I will give a summary of my ruling, and I will avail to you the detailed one later. But briefly, the Constitution told the court that they had witnesses around the court. The Constitution said that you are ready to proceed. However, the chosen persons, specifically A1, raised some concerns. Briefly, the concerns that affect the legal representation. To be specific, the concerns he raised is that one, that there is a pending application number 248 of 2026, which is still pending before this honorable court, and it is related to the issues of legal representation. According to the chosen persons, that is A1 and A2, they told the court that this application should be disposed of first. I will come back to that. They also raised the issue, the chosen persons, of the disclosure. The chosen person said that the disclosure was made to their lawyers, who have since voted the challenge, and for them, they have not received the disclosure, and also come back at it. The chosen persons also informed the court that they want to be availed with the record of proceedings in this case and the applications, which will also come back to it. Another issue of concern was that the facilities in prison, which prison wrote this honorable court as of the 29th June, that the same be availed to the chosen and their team. Another concern is by S3 who raised the issue that he was not given a copy of the ruling in his bail application. Briefly, I will now proceed to make the following remarks and findings on those summaries of the concerns raised by the chosen persons. 1. I am very well aware and alive of Article 28 of the 1995 Constitution. Briefly, Article 28 provides for the right to a fair hearing. I'll go ahead to Article 28.1. Article 28.1 provides that in determination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. I have also considered Article 28.3d of the 1995 Constitution. It provides that is 3d, that every person who is charged with a criminal offense shall be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. Indeed, from the time we started this case, the two persons were permitted the lawyer to the services of the lawyers of their own choice. Not until 30th June and specifically 3rd July, when the lawyers of their own choice that had been representing them were not present in court. I will now go to Article 28.3e. Article 28.3e of the 1995 Constitution provides that, I quote, in the case of any offense which carries sentence of death or imprisonment for life, the accuser is entitled to a legal representation at the expense of the state. In this instant case, and specifically the concerns raised by the chosen persons, I will address all their concerns one by one for the interest of persons. Concern 1, that miscellaneous supplication number 248 of 2026, which is allegedly to be pending before this honorable court, or specifically before me. Cases normally are allocated to the judges. Judges don't allocate cases to themselves. I want to make it clear that from my knowledge, miscellaneous application number 248 of 2026, which the accused persons are talking about, has never been allocated to me as a judge. It's not before me, but the registrar can find out from the registrar who allocates cases. But the said application has never been allocated to me, and the same application cannot use it or debate it to hold this trial, because it is not until that the same application is allocated to me that I would know the content. But at this stage, I don't know the content of that application, which has never been allocated to me, that I can form mind to hold this trial in session number 335 of 2020. I go to the issue of disclosure. The accused persons have told the court that the disclosure was made to their lawyers. True, from court record, the final and full disclosure was made on the 1st of June 2026. And I will take what the accused persons have told me, that they have never received such a disclosure since the disclosure was received by the lawyers who have since brought challenges. I now order and direct the prosecution that for the interest of justice, at the end of this sitting, I'm ordering you make avail of the disclosure to the accused persons before court here on their own, since the other one, according to them, was made to their lawyers. So at the end of the sitting, prisoners kindly hold on, allow the prosecution to avail all the evidence they intend to use in this case, avail it to the accused persons themselves. In case there is any challenge of the prosecution to do that, serve all the evidence they rely on today, of which I believe, I told court that there were already witnesses. Yes, they had that evidence they intend to do, so avail it to the accused persons themselves. On the issue of proceedings, this case and other applications, I'm directing the Registrar of Criminal Division to avail the copies. In any case, the proceedings are by transcribed. So the IT should help the registrar to have these proceedings in this main case and applications, so that the registrar can satisfy them and serve the accused persons. This one can be done by tomorrow, which is 14th. And let the registrar, the IT, together with the museum, prison, they should get these proceedings and avail them to the accused persons. I will now proceed to the facilities in the museum. As the accused persons and specifically A1 put it is on record that at least by 29th June, the Muzira people wrote this honorable court, and the letter is on record, that they had granted almost several facilities to the accused persons and their legal team, and directing Muzira to adhere and the same. I want also to go ahead and comment on the ruling for S3, that it was unfortunate that you have not received the copy of your ruling. Yet this court directed the registrar and the Muzira people to avail you with this ruling. I will now again direct the registrar and Muzira people, even Muzira people before you go, to make sure that find out where it is, whether with the registrar or in Muzira, so that this is able to get his copy. For the interest of justice, and specifically to address the issue of representation, the chosen persons have been represented by lawyers of their choice as per Article 28, 3D, from the time we started this case, at the time of the pre-taken. However, it is my considered view that the chosen persons were permitted to have lawyers of their choice from day one. But since this court keeps getting concerns from the accused persons that they have challenges with their legal representation, specifically lawyers of their own choice, this honorable court will move to look at the relevant laws. In the case such a challenge keeps on, because my view is that there must be a solution for the trial to commence, and I am aware and alive of the right of the fair hearing. And my view, this case has suffered several delays, and indeed that two of the persons have said they have been on remand for some time. So this honorable court has decided to invoke Article 28(3)(e), which provides that accused persons are entitled to legal representation at the expense of the state in the cases of any offense which carries a sentence of death or imprisonment, life imprisonment. In the view of the above, the registrar criminal division is directed to avail a list of all lawyers in the criminal division for all the state brief, which criminal division has a pool of lawyers on the state brief. So, in order for the accused persons not to suffer with the challenges of the legal team which keeps coming, the registrar should avail to the accused person that list of all lawyers in the state brief in the criminal division. And then this list will be given to the accused persons through zero. For the accused persons to look at this pool and choose as a fallback, choose some lawyers of their choice for the purposes of this trial. And this registrar is directed to do it by tomorrow 14th and send this list to Zira through the legal officers so that the accused persons can look at this list of lawyers and be able to choose from them the lawyers of their choice. And this doesn't stop any other lawyer of the choice of the accused persons to join the team of state lawyers, of lawyers of the state team. So the accused still has the right to get lawyers of their choice, but in order for this trial have a direction, let us have a list of lawyers on the state brief from criminal division, selected, chosen by accused persons themselves. In alternative, for the purposes of this trial, if the accused persons don't choose the lawyers from the state brief on their own and make their own choice, then I go ahead and make a direction that the registrar criminal division by tomorrow, if the accused person have not chosen from the pool, then let the registrar go ahead and appoint the lawyers on state brief to help court and accused persons to proceed with this trial. I'm invoking Article 28(3)(e). In the same vein, for the interest of justice, if the registrar appoints the lawyers on state brief other than the accused persons choosing for themselves, then either way, if the accused persons select and choose and all the registrar appoints, the prosecution is directed now to go ahead and make prepare all the evidence they intend to use to give it to these lawyers chosen by the chosen persons who are appointed by the registrar. So the prosecutor will get in touch with the registrar to know if the chosen persons have selected those team of lawyers, avail them with the evidence we intend to rely on. In conclusion, this case is adjourned to Wednesday, 15th at 11. Shall meet here and to know that the orders and directions of the court have been
Clarification.
Yes. Please let me put you on the
Yes, please, on issues of clarification.
Yes, let me put you on the yes, please.
Yeah, first one on our application 248, which you have said is not before you.
What is number 248?
Yes, which is not before you. For us, we just make applications to the High Court. Now, this application very clearly directly relates to the matters before you. We have been presenting this matter before you since the 30th of June. In the appearance of the 30th, in the appearance of the 3rd. In the interest of justice, which you keep referring to, have you taken any interest to find out where this application is that relates to this matter very critically, and that fundamentally affects our rights? Because once we file an application to the High Court, that's all that we can do, which we did. Secondly, I pointed out that we have filed a notice of appeal on the application, appeal on the ruling that you made in respect of application number 227. Again, an application that fundamentally impacts on the main case. So we have an interest in continuing to pursue that application 227 in the Court of Appeal. And if the process of trial continues as you have guided, then sure our appeal will be completely negated. Thirdly, the schedule you have given us now did I get it correctly that, because I don't have anything to write on my, as I pointed out at the beginning, we were arrested from the prison and brought here forcefully. First time I'm being arrested in prison. So we didn't come prepared. But the question I'm asking on the schedule, did I hear correctly that the disclosures will be available to us in the course of this evening? That tomorrow we shall get a list of government lawyers from which to choose. Or if we have difficulty choosing, the registrar will tomorrow appoint lawyers for us. And that in the same tomorrow, the appointed lawyers will receive the disclosures from the prosecution. And that then trial will begin on Wednesday. If what I heard and I have recounted is the case, then quite clearly the intention of this process is not a fair trial. Very clearly. Because you expect us to choose lawyers tomorrow, receive disclosures this evening. Disclosures, he said, we receive them this evening, they will be given, but lawyers will get from them tomorrow. So clearly we shall have no time at all to sit with the lawyers, whether of government or otherwise, to review the disclosures, which, as has been previously pointed out to you, are voluminous. And we should start trial on Wednesday. Clearly, if such a process is insisted on, I don't see.
Ask clarifications, then I will give. So don't.
So I come back after you have clarified.
You first listen. Let me first know the clarifications.
So those are the clarifications, but the reason I'm asking for them is the concern that I am presenting. Or you want me to present the concern after you have confirmed otherwise?
I'm saying let me get those clarifications. You said you have those clarifications. You want, and so I gave you the things to raise.
Yes. I have raised the clarifications I need. I was now going to raise the reason these clarifications, if they are, especially the third one, which I have raised, if it is if I understood the guidelines on timings correctly, what its impact will be on us. If you want me to raise that later, I can. Yeah, so I was simply saying that fair trial, very clearly, very explicitly, non-derogably provides that the accused should be accorded enough facilities and time to prepare. So we are getting the disclosures this evening, hopefully. The facilities to use those disclosures, to access those disclosures are still a matter that is out there. Whether we will get the facilities that we need or not. The lawyers are being appointed tomorrow and trial begins on Wednesday. So, that being and this is why I wanted to talk about Mr. Museve's statement and impact, because he clearly directs a different legal justice system, where he says if an accused denies an offense, it is provocative and will be dealt with by those he has appointed to fill that gap. The criminal justice system that I present myself to arises indeed from the indigenous communities of this country, which made a constitution in 1995. That constitution is the result of all the indigenous communities in Uganda. So if there is another indigenous community that still has something different from this constitution and is using it to impact the process of legal justice now. This, you see, impacts on what I'm saying. I'm talking about the impact if what you have provided that we start trial on Wednesday is the case.
Why don't you wait for folks to clarify?
You see, sir, the reason indeed we are very frustrated and we were even unwilling to come to court because this in many times appears as if we are irrelevant. We present whatever we present, court goes on with its script. So the impact will be that possibly you may have trials in absentia so that it hastens the process. We give up our right to defend ourselves. You write a judgment and we deal with the judgment.
didn't raise my...
Well, it will arise. It will arise because even the trial by state lawyers is a matter that we raise the concern about, because we have been hearing it right from the way back, that our lawyers will not be allowed to represent us, and indeed they have been tortured. The torture pictures published to the public and all the other lawyers, who after the pictures that were published of Counsel Yasser under torture, now he's being taken to India for further surgery. Who will, if we don't resolve the environment surrounding our... Yes, but you say you don't know where it is.
Yes.
We have raised it on the 30th, we have raised it on the 3rd.
And requesting the court order is, if the public will see that they want to be violent, and why can't you give them a chance to stop?
See, our frustration, sir, is that application which we made long before the bail things came in, we don't know where it is. It's a human rights area. Yes, and it impacts it. So we are now going to start trial because we have failed to get lawyers. You are providing state lawyers. We have not failed to get lawyers at all. We have the capacity to get the lawyers of our choice, but not in the environment the state has created, which we want court to deal with, so that then we can go ahead and appoint our lawyers and the case continues.
One of the concerns that arose in the ruling yes, Thomas Jatiko, Assistant DPP. One of the prosecution has carefully listened to the ruling, and this ruling orders or directs the prosecution to avail and disclose to the accused persons all the disclosure today before I believe they leave for the prison. Ballot is after 5 p.m. and the prosecution does not have all this evidence in court here to avail to the accused persons. And my lord, this evidence is voluminous, as the prosecution already served over 10 lawyers with this evidence that is constituted by witness statements.
So, are you saying therefore the accused should not?
My lord, we cannot disclose to the accused persons by the close of business.
So what are you suggesting?
My lord, we pray that the prosecution can be able to make this disclosure by Wednesday, because we need to have forensic evidence transferred by the forensic expert, who I'm aware is presently in a training, and between now and the end of this court I cannot do so. Even tomorrow I cannot do so. I cannot be certain. My Lord, we would pray that this court be pleased at the most to permit prosecution avail this evidence, at least by Wednesday, because for now and tomorrow it is impossible. My Lord, this is because we already gave all the copies we had to the defense team, who are over 10 or 12 at the time, and we are only left with the original copies. My Lord, in any case, the lawyers that have been representing the accused persons severally have these pieces of evidence. They can turn it over immediately to the accused person. We humbly pray. My Lord, just in addition, from the further directives in this ruling, it also will mean that the prosecution may also have to serve the new counsel who will be selected. So, my Lord, this period between now and the time the prison people leave, and even tomorrow, is not sufficient for the prosecution. Humbly reiterate our earlier prayer. God be blessed. Grant us more time.
Specifically on the issue of the schedules that this court has given. This honorable court has gave directions to each party, including the register and the constitution. I still say that let the registrar avail the accused person is released by tomorrow and send it to the exam for the accused person to choose the lawyers of their choice. For the issue of disclosure, since the Constitution was saying that we don't have that evidence of which the chosen persons must get, prepare the same evidence that we intend to rely on, and then make a full disclosure here on Wednesday. It is on that Wednesday that this honorable court will know that one, the issue of legal representation is sorted, and the issue of disclosure is sorted. One conclude, commenting on the application, number 248, that as a judge, I don't go looking for cases. However, I will take interest now in it. Because I was waiting, all cases which are located to me, I wait in quickness and here. So that one by this day, still you will know who is handling that case on the issue that is raised in this matter. Let us wait and see. Because I don't know the context, I have not known. But let us wait for the Wednesday. As you have said, I'm going to find out Mission Street. And on Wednesday, we shall harmonize where who is handling that because of not knowing. So let us meet here on Wednesday at 11.
You haven't commented on the impact of our intended appeal in 227.
That one you said you appealed, and I have ordered that you get the proceedings.
Yes.
Yes.
So the trial will continue as we appeal.
Then council, go council, to help us. Now, you said you are getting a report from here.
Yes, there are not so many days with the office.
So let us tell them you
Yes.
the report. Now you want me to start now in this one, start again here. I don't know what I can say. Entertaining you, that application. He will guide you through the process. On that. Assuming Councillor Simo will guide on that case. For me, what I'm going to do is let us get the report, the notes you have given it to me. Let us please get the report and you appeal. It is your right.
So by Wednesday, we shall have all the report.
I think so. What is